Good morning, everyone. So the Chief Justice is joining us remotely today, so I'm going to be presiding. We also have Justice Pierce, who is about to be retired, so he is not sitting with us. And we have Judge Eldridge from the 4th District, who has agreed to join us today. Just so everyone knows, sometimes we keep asking questions even when your time is up. So if we're asking questions, you can keep answering them. If that means one side gets asked questions for more time than the other, don't take that to mean anything about the case. It's just that we had more questions, okay? All right, so can I get appearances of counsel?
If I may interrupt, Justice.
Oh, yes, thanks, Chief.
I just want to apologize to everyone for not being there in person.
Thank you, Chief. And we'll watch for, if the Chief has a question, he'll do the little hand sign on WebEx. So we'll try to make sure and watch for that. All right. Okay, can I get appearances of counsel?
Thank you. Deborah Bulkley for the petitioner, Jacqueline Smith.
And David Pedrazos for the respondent, Daniel Smith.
Okay, thank you. You can go.
Thank you. May it please the court. The starting point in determining alimony in the state of Utah has been, for quite some time, the financial condition and needs of the recipient spouse. And in considering the financial condition and needs of the recipient spouse, the starting point should always be considering the economic circumstances with the goal of equalizing the post-divorce standards as closely as possible to what existed during the marriage. It is axiomatic, it is well settled under Utah law that alimony is not limited to providing only for the most basic needs. Instead, it should be fashioned to take into account the station of the recipient's life in light of the standard of living. And the equalization is also part of this. The statutory standard provides for both equalization and that the court should take into account the financial condition and needs of the marital standard of living.
Can I ask you, I just want to get your position on exactly what happened here, because then it helps me know what legal issues might be at issue. So it looks to me, in looking at the district court's order and then the transcript that you attached where the court was going through the different expenses, it looks like in that first number, the needs, that the court determined, that 4,184, the court was trying to make a determination of those expenses at the time of separation. Because in the transcript that you attached, the court kept saying, okay, yes, I understand we're talking about housing costs, but I want to know the cost that would be commensurate with the standard of living at the time of the marriage or at the time of separation. So I'm trying to understand what this 4,184 is supposed to be. The court said a lot of times in the transcript, no, I'm trying to ask what it would be commensurate with the standard at separation. But then in the order, it says needs at the time of trial, I think. So what's your position on this 4184? Is it based on the standard of living at the time of separation or at the time of trial?
Your Honor, if I may, well, I wasn't trial counsel, but looking back through the record, and I think I think what the trial court did is what was found to be an error in both the rule, and there is a couple of Gardner cases, the first Gardner case, where what the court did is while they were going through the expenses at trial, which you're correct that it was discussed that this should be considered according to the marital standard. Basically, what the court did at that point is he said, well, I'm going to say, well, you know, took some of the expenses and said, for example, with I'll just go with the personal care that Jacqueline was claiming. For example, she had claimed, let's see, $136.74 in self-care each month. And that was consistent with her marital standard of living, where she would get a haircut and occasionally go to a nail salon and maybe get a massage every once in a while. Now, when he was going through that, he says, well, I'll give you the haircuts, but I'm not going to give you the massage and the
Right.
nails. So I think he was kind of trying to trim it down to what the basic needs were, which is what the trial court did in both the Rule and the Gardner cases. They took a list of expenses that included both needs and wants, both the financial conditions and the needs, right? And said, well, I'm just going to give you the basic needs.
Yeah.
And that was found to be an error in both the Rule and the first Gardner case. Now, I think what the trial court did here, though, is then after going through that analysis and saying, I'm going to find out what your most basic needs are, is he took into account the fact that both the combined income had reduced somewhat by the time of trial. I'm not sure why, but it had to a combined $11,000 a month. And so when he got down to the basic needs, it was somewhere around $4,000. But that didn't take into account, some of these other things that were being claimed. Like, for example, I know that there was also a discussion of the retirement savings and how those had, increased. Daniels had increased by the time of trial. And the judge, and the argument at trial was, well, he shouldn't be able to contribute more to take away from what the alimony payment should be. So I think in those regards that that the testimony and the trial court's reasoning were like, okay, I'll figure out what the basic needs are, and I will put that back into kind of bring it back up to the marital standard, rather than the way that the statute and case law is laid out, where you're supposed to take into account the needs and the financial condition in light of the marital standard as a first step. I think the trial
Right.
court in this instance did that as the last step.
Okay, yeah, and I guess that the transcript of it's sort of a mix, because on the one hand, sometimes the court says, if you had a cell phone during the marriage and you don't right now, I want to know the cost of a cell phone, because that would be the standard of living. But then at other times, he does cut down on the expenses, saying, okay, you don't need the massages or whatever. So you're saying to cut down when you're giving at the time of separation expenses, when you're saying, look, here's what it was, that the court should not be making cuts to that. It's just or is that what you're saying? So that it was error for the court to go through those expenses and say, well, I'm not going to let you have this, but I'll let you have that.
Yeah, I think the way the court, I think that this would have been an error, and maybe a remand is merited to review this under the light of the proper standards. The light of, not the proper standards, but the proper procedure that trial courts typically go through in these cases. Because what the court did here is on the first step said, we're going to trim it down to the basic needs, but then added it back, kind of cured that error by adding back in the needs. And if you look at what the total amount was on the financial declaration versus what the...
And can I ask you, is Exhibit D in your addenda, is the first page of that the financial declaration? That's the chart or the table? Because mine doesn't say current expenses or marital expenses just has the numbers?
Your Honor, I believe it was, I can get an answer for you more exact in rebuttal on this, but I believe that it is based upon the declaration, that it adds all of the financial evidence to back it up.
But are those the current expenses or the marital, or the expenses that reflect the marital standard of living? Because the Court of Appeals seemed to think that those were the current expenses and that there was no evidence presented of the marital standard of living.
Your Honor, I believe these were the current expenses based upon the marital standard of living, if that
Okay.
makes sense.
Yes, it does.
And it looks like the documentation is all, the rest of the things that are in tab D is all from like 2021. So the separation was September 2020, right? That's the separation date. And then all of this documentation is 2021, which I can see how that would sort of, unless it's different, that might encapsulate what it was like in September 2020. But I'm not sure. So is this, all of the documentation and this chart supposed to be expenses, but at the same level that they were during the marriage, at the time of separation?
Yes, Your Honor, I believe so. And if you go through the trial transcript, I mean, most of this is proffered, but there are several discussions of like, well, why is this expense so high? Well, they would go on a vacation, and this was eating out, and they go on a vacation. So I think that that's also incorporated into the proffered testimony, Your Honor.
Okay, one last question just on the facts here. I don't totally understand what the court did at step 3. So we have this first number, which is need, which seems like it's a bit of a mix of time of separation and the court cutting it down. So maybe to just basic needs. Then ability to earn, ability to pay. But then in the order, the court just says, well, the parties can't be equalized at the standard of living at the time of separation. There's not enough money for that. So then I'm going to, because there's a shortfall overall and they both can't live at the marital standard of living, I'm going to equalize them. And the only information for that is that during the marriage, they made a combined $175,000 a year. And now it's $11,000 a month after tax. And I don't know what to do with those numbers because I don't know if the $175,000 is gross or net. And then the $11,000 a month is net. So if the $175,000 is gross, I'm not sure how much difference there is. But if $175,000 is net, then there's a big difference, but I don't know. And so I think this is a difficult thing to know how this last step kind of just comes in out of the blue, and it's hard to understand exactly how it's relating to what happened in determination of the standard of living at the time of separation. Do you understand? Do you understand what happened?
So, Your Honor, my understanding is that what happened is that for whatever reason, the net income, I'm not sure if this 175 is the net or the gross, but the net income was less for combined. The combined net income was less by the time they got to trial. So the number the trial court used as what the combined income was the $11,000. So when sorry, I'm just looking back through here. So when he's coming through here and making his analysis, he went through and he basically said, well, I'm going to, they both have a shortfall, right? Because they're not, neither one of them is going to be able to live at the marital standard. But what we're going to do is split that $11,000 that they currently have. I think that's where the equalization came in. It's based on the $11,000 current net income, not based upon the marital $175,000. And if you look at the difference between what was in the financial declaration and what he came up with for the equalization, it was only about $75 more than per month than the $1,500 that was the marital, the difference between her actual expenses that she listed and her income was not that far off from
The final
from
number.
the
you gave.
final thing. It was a little bit higher than what she came up with in her declaration, but that was based upon the equalization. So I think that using that $910 was way too, a month was way too low, because that would be based upon only the basic needs, which it's been clear under Utah law since, for decades, that the standard should not be basic needs, that it should be the financial condition and the needs, and that's what's in the statute.
Okay, but assuming that, let's say that the court hadn't reduced the basic needs. Let's say that that he came up with a shortfall of $910 using the actual marital standard of living. Would the $910 be the most that he could award? Is the shortfall?
No, Your Honor. And if I could, I know I've just got about 20 seconds left. That kind of goes into the demonstrated need argument. I think that under the case law, when you look at it in context, the cases that have cited to demonstrated need, they're not really talking about need. What they're talking about is the financial conditions and needs in light of the marital standard of living. Like if you look at the Rule case mentions the demonstrated need is the maximum possible alimony award. But it's not talking about, gee, she needs, her rent and her groceries, and, this is her basic needs, therefore that's her alimony cap. No, what it's saying is, when you take into account what they had during the marriage and their lifestyle during the marriage, that is the cap.
I agree with you there. So you're saying that the court shouldn't have reduced it. If the court hadn't reduced it, what would her shortfall have been?
Your Honor, it would have been around $1,500 a month, Your Honor.
Okay, so my question is, let's say that he had done exactly what you thought, what you're advocating in step one, found that her shortfall was $1,500. Is that the maximum amount of alimony that could be awarded?
No, Your Honor, because the court also has discretion to equalize the income to bring them closer to the marital standard of living. And in the statute...
But I think the premise of her question, tell me if I'm wrong, is that if the court did this from the marital standard of living, at the time of separation, so let's say he makes no cuts, and that everyone agrees hypothetically, and we're not saying it is, but everyone agrees hypothetically that the court finds a shortfall that is from a number that is the marital standard of living and not just basic needs. And is that a mandatory cap? Is that?
That's exactly right.
Oh, I see what you're saying. Sorry, Your Honor, I misunderstood the question. And first, if I could just correct myself, the disparity was actually closer to $1,919.25, whereas the alimony awarded was $1,975. So it's within, pretty close to what was awarded. But yes, Your Honor, I think that if you look at the case law, I think that the court can deviate from what it deems to be the need considering the marital standard of living if it makes if it deems it appropriate. I think that there is discretion there, but I think the case law makes it clear that if the judge is going to exercise discretion to go above and beyond, that it needs to have a reason, like perhaps fault or things like that. But I think that is pretty clear in the case law that the standard alimony determination should be the financial condition and needs considering the standard of life that the recipient spouse enjoyed during the standard of living, and that the equalization should generally go to that. But I think there are exceptions, but that's the general rule.
So you keep referring to our case law, which I completely understand, or the Court of Appeals case law on this. Is it consistent with the statute to say that if you did step one correctly and you got a shortfall based on the marital standard of living, that that is at least generally the cap for an alimony award? Is that consistent with the statute? I know that's consistent with the case law.
Well, I think it is consistent with the statute if you take into account the fact that the trial court does have a lot of discretion with alimony. It's written all over the statute. And the equalization and the marital standard of living are separate parts of that statute, and they have been. I know it's been recently recodified, but even before the recodification under the law in effect at the time, the trial court still had separate discretion to equalize the standards of living. And I think that under the case law, that is, the case law does recognize that, but the case law also says that the trial court has to have a reason if it's going to go beyond that. But I think under the statute, they are two separate factors. There's not one factor that's determinative of any of the other factors. And I think that was clarified with the recent recodification, but it was existing at the time of trial as well.
So it seems like in the case law, the equalization is for when both people can't exist at the standard of the marriage in two separate households, so you kind of equalize the pain. But is that what the statute says? The case law says that, but does the statute just give kind of discretion to equalize, even if you can meet the needs, the receiving spouse can have her needs met and live at the standard of living of the marriage? If there's more to go around, can you still equalize that under the statute, separate from the case law?
I believe that a trial court could, Your Honor. I think that the key would be, if you look under the statute, I'm looking at the one that existed at the time of trial right now, when it was still 30-3-5. And it said the court may, this is a separate factor. It says the court may, under appropriate circumstances, attempt to equalize a party's respective standard of living. So I think as long as the court found appropriate circumstances, it could under that statute. And then and then it's also under the current statute. I think the current statute may be a bit broader than what was under the one, because it just says the court may attempt to equalize, and there's no appropriate circumstances limitation. So I think under the current statute, it's clear that they're separate, and it was also separate under the statute existing at the time of the trial, Your Honor.
Chief, do you have any questions? All right.
Not, thank you.
Okay, thank you. All right,
Thank you.
Thank you very much.
May I please the court? One of the things that I wanted to point out in hearing the discussion and certainly all of the pleading is I think we need to make a clear distinction that there's a difference between equalizing the standard of living and equalizing income. Those are two different things. As I often describe and argue before the courts, if someone makes $200,000, but their standard of living is $50,000, at least as I read the case law and so forth, we should be dividing the standard of living based upon $50,000, not $200,000. And I think that's a very clear distinction, because I think that's what the trial court did in this case, is he went through his analysis and figured that there was $910 of demonstrated need. And then he said, okay, but, respondent had excess income of $3,950, and he just went ahead and divided it. And
Didn't the court do that because he understood, at least in his view of the evidence, that the party's income didn't meet their marital standard of living needs? And so it might have been a shortcut. I can concede that, but I don't think the court here just said, oh, the needs are, at this basement $100,000 level, there's an extra $200,000 of income out there, I'm just going to divide that between the parties. It seems like he was trying to equalize the standard of living.
Right.
He just did it perhaps in a shortcutted way. Would you agree with that?
I don't, because I think even under Dow v. Dow and certainly under all the numerous cases in the Court of Appeals cases, it doesn't matter if the obligor, in this case, or the payor, has the ability to pay excess amount of dollars. It always comes back to what the demonstrated need is.
Right, and I guess my read of what the court at least was trying to do was make sure her needs were all accounted for.
Right.
And he recognized that the amount that the parties were making, the income wouldn't meet that marital standard of living. And so rather than go through and perhaps, detail what those needs were exactly, he knew that if he divided what was left of that income, it still wasn't going to meet the marital needs. And and I think that would be consistent. If I'm right, if I'm reading him correctly, would that be consistent with the law?
I don't believe so. Just because in the analysis is he went through very specifically and he determined that Jacqueline's needs were $51.93, that he showed that, and then he reduced it to $41.84. And then, of course, he reduced Daniel's monthly expenses to $47.16 per month. And then, of course, he found that Daniel had a net income of $7,507.
Do you have an understanding of why the court made those reductions? What was his basis?
Actually, that's a very good question, because the way I read the statute, and certainly I had quoted certain sections in my brief, he went through with counsel and then, of course, Daniel, because he was unrepresented at the time, and he went through all of the specific numbers, and there was a discussion on each one of them, and James Woodall was the counsel for Jacqueline at the time. He agreed to most of them. He agreed to all of the reductions. The only one that he pushed back, and I even pointed it out in my brief, was the housing expense. That's the only one that James Woodall pushed back on. All of the others, if you look at the transcript, he agreed to all of the other reductions.
But did the court explain why he was reducing?
Yeah.
And what was the reason?
It depended on each one, but for instance, on the travel expenses, for instance, he reduced hers, but he also increased Daniel, so that was an equal amount. I think it was an equal amount of $600, I think he arrived at. And so he was just adjusting what was appropriate and trying to equalize, well, if I'm going to give you X amount of dollars on food, I'm going to give the same amount to Daniel. And so he adjusted it accordingly. But in essence, which I think is clear from the record, there wasn't sufficient evidence as to what these expenses were. So he was trying to do his best. And I guess under the statute, or not the statute, but under case law, where a court does have the ability to fill in the blanks and make adjustments. So he does have the ability to do so. But I think he was doing what was fair and equitable when he arrived at those numbers. And
So do you think when he set that final need number for each of them, that he considered that to be the marital standard? Or the needs as reflected by the marital standard? Or do you think he considered that number to be a figure that reflected the current needs?
I think it was based upon the marital standard because, as Judge Peterson pointed out, when you look at the transcript, he says, I'm trying to arrive at the marital standard of living. I'm trying to figure out what the parties' expenses were. And he asked several times, and even James Woodall, that was counsel at the time, was agreeing to his numbers, agreeing to his adjustments. And so it's quite ironic to me that during the trial, or, petitioner's counsel in this case, was agreeing to everything. The only pushback that I saw when I read the transcript was just the housing expense.
So did the Court of Appeals misunderstand the court's order then when it said there was no evidence of the marital standard? Because that's why it reversed it, right? It said these were different numbers than the marital standard, so that's why it reversed. So did it misunderstand?
That's a good question. I guess it's a matter of semantics, to be honest with you, because when I read the transcripts and so forth, they were saying basically what the current expenses were actually reflecting the marital expenses. And so in argument under the Court of Appeals and even here today, they're saying, well, her marital expenses exceeded what the court found to be, I think it was $59,130 or $51.93, which was her expenses. I'm sorry, the court found $41.84. But they were arguing that it exceeded more, but the issue was there was no evidence to support anything above and beyond the 4184, really her expenses that were reduced, which was the 5193. There was nothing that was ever presented to the district court to support anything above and beyond. And so yes, was he determining marital
Well,
or?
I was just going to say, I mean, I think there was, right, because she did present a higher number. So to say there was no evidence to support it, that's why I was wondering
Oh.
why the court reduced it. Did he
Right.
reduce those saying, I haven't seen any evidence of this? Or as counsel suggested, did he reduce those because he was trying to identify the very basic needs versus perhaps a need that was reflective of the marital standard?
My understanding is when he reduced it from the 5193 to the 4184, I think he was just trying to use a reasonableness standard and what was fair.
Okay.
Because, you know, as often in the cases, yeah, someone submits inflated numbers, and then it's up to the trial court to go through the numbers and reduce or increase or whatever. And I think he was doing within his ability to do so. So I think he was trying to, because as the transcript says several times, I think he was trying to figure out the marital standard of living. But one thing I find interesting, though, in all due respect, is petitioner in this case never appealed that before the Court of Appeals, and that only issue was brought up before this court.
Well, I think in part because, at least I didn't read your appeal brief in the Court of Appeals as challenging the sufficiency of the evidence.
Right.
So I feel like things have shifted a bit, but I think it's in part because of the way the Court of Appeals resolved the case.
Right.
So are you saying that the Court of Appeals got it right, but for the wrong reason? That the reason that the district court was wrong is not because there wasn't any evidence of the standard of living, but because the court did have evidence of the standard of living and then awarded alimony in excess of the needs as demonstrated by the standard of living.
I'm trying to understand your question.
Sorry, let me say that again. Okay, so my understanding of the Court of Appeals opinion is that there was no evidence of a higher standard of living,
Right.
right? So the court, in their view, the district court kind of skipped the first step, right? Because all there was the current expenses, and then it tried to equalize the income from there without actually determining what the appropriate shortfall was. But are you saying that, no, the court did, the court was using the correct measure, the standard of living during the marriage, not the current standard of living, and the error was just the court equalizing the income above the shortfall that she had? Does that make more sense?
Yes, it
Okay.
does. Yeah, it does. And I think the confusion is actually well-founded because, yes, under the financial declarations, it listed her current expenses. And yes, under the financial declarations that was submitted, the marital expenses were blank. And so when the judge and the district court tried to make a ruling, he was trying to figure out what marital was based upon the current expenses, and that's why he made some of his adjustments. And so to me, when I was responding to Judge Pullman, I think it is kind of semantics because in a way, he was trying to get was right, but then you have petitioner coming and saying, well, wait a second, we need to justify this additional $1,000 or $1,100 in alimony that was awarded, and that was the marital expenses. And I'm saying, no, there was no additional evidence beyond the 910. The 910, in my opinion, was the marital or current expenses. So how we got this inflated number of this 1975, they're arguing it's marital. I'm saying, no, it's not, because there was no evidence to support those numbers.
So let me just make sure I understand then. So you think when they submitted that exhibit and she had over $5,000 in expenses, those reflected current expenses?
Under her financial declaration, it was, but as
I mean, I know they're in that column, but do you, based on everything in the evidence and what the parties testified to, do you think that was indicating what her current expenses were?
it was indicating what her current expenses was, but like I said, when Judge Faust was questioning him all those expenses, James Woodall, which was the counsel, he was agreeing that those were marital expenses too. And the judge kept saying, are these marital? Because I'm trying to establish marital. So he was making an effort to establish what the marital was. And James Woodall was saying, yeah, those were marital. And so.
But that would suggest that the marital standard was lower than the current, which doesn't seem really consistent with everything else that the court said in his order.
You may take that interpretation, but at the end of the day, there was no evidence to support otherwise, though. I mean, that's where it begins and ends, in my opinion, is if they would have submitted all of the evidence to support this 1975 figure, then fine. But the fact is they only submitted enough evidence to support this 910. And this also goes back to this court's case in Dow v. Dow and all of the other cases in the Court of Appeals, is they have the burden of proving what her needs are and expenses. And under Dow v. Dow, it was very clear to this court, and you guys made a very good ruling on it, was she has the burden and she failed to meet it in that case.
Can you show me where in your appellate brief before the Court of Appeals you challenged the sufficiency of her proof? As opposed to just the court's findings?
I think the sufficiency was, as I always said, that I took the court's numbers and I never argued the court's numbers. The only numbers that I argued is the court made a determination based upon its analysis of $910, but how it arrived at 1975 as the actual order of the alimony is what I was challenging. I was never challenging the 910 or the expenses originally at 5193 that was reduced to 4184. I never challenged his numbers.
So you weren't saying that the district court's calculation of 910 failed for insufficient evidence. You were just arguing that she didn't put on additional evidence to support a greater amount.
Correct, yes.
But I would like to understand where that was in your brief. Because your brief argued that the court basically didn't show its math and there was insufficient findings, which suggested to me you were looking for additional findings to support what the court found. Not that you were arguing there was a lack of evidence in the record. That's what the Court of Appeals concluded, but I didn't see that in your actual briefing.
And I apologize if I definitely know I argued that in the appellate court briefs, but in the Supreme Court brief, if I overlooked that, I'm sorry. I was just merely focusing on the two questions that were posed by, in the order of I think it was Judge.
No, I think you actually did argue it in our briefs.
Right.
My question was whether you argued that in the Court of Appeals briefs. Because part of the argument being made is that the Court of Appeals overstepped here. So I was just trying to get to that piece of the argument. And I was just wondering where in your brief you were making the sufficiency challenge.
I can point it out in my brief before the Court of Appeals. What I was pointing out in the Court of Appeals case was simply we weren't disputing the 910 and we weren't disputing the 4184. What we were disputing is how all of a sudden, he says that her needs are 910, but all of a sudden I'm going to go ahead and divide his income and get to 1975.
Right, and I agree with that. That's how I read your brief as well, is that you were looking for additional findings to support that increase.
Right. I can go through it and try to find it in my Court of Appeals brief, which I do have here, but I think that was in essence is what I was coming down to, was we never disputed the 910 figure, how he arrived at it. We just disputed how he arrived at 1975.
Okay.
Is it normal for, in calculating the standard of living at the time of separation, so let's say that the wife gets a haircut every month, every 4 weeks, and gets her nails done and has a massage every month. Is it normal for the district court to say, that's not reasonable, you only need a massage once a year and you should be getting your haircut like every other month? Do district courts, do they have sort of a reasonability of the marital standard at the time of separation, or is it more an empirical question of just what was it?
I believe the court has the innate power to go ahead and adjust up or down depending on the circumstances, based upon reasonableness. There's certainly case law that the court can impute numbers if, there isn't sufficient, proof that, like if there's $1,000 for food and household, but, one side didn't provide the proper documentation, the court can put a reasonableness is the way I read the case law. And I think it goes both ways, and I see it all the time in all of my cases, is the court can adjust it, up or down, because often in these cases, which was actually in the Dow v. Dow case, is the petitioner, or at least the wife in that case, submitted a financial declaration of $40,000, and the lower courts rejected it because it didn't find it was credible. So the court is not obligated to accept all of the numbers on a financial declaration. They can adjust it based upon reasonableness and so forth. Now, if one side does present proper documentation to what your question is and said, I had, haircuts, each week, let's say, and here's the receipts, and I can show the receipts going back 5-6 years that I had weekly haircuts, then to me, for the court to reduce that, I think would be error. But in these cases is we just have a financial declaration and we don't have proper documentation, and that's clearly what was happened in this case.
So the court can't simply say, well, that's not how I would have spent my money, or I don't think that's an appropriate way to spend your money. If that's how the parties spent their money, then that's the marital standard of living. Is that right?
Correct, yeah. I mean, I've seen some bizarre cases out of Park City where they were providing bottled water to their dogs. And that was the standard of living, and, the court accepted it. So, yes, as bizarre as some of these expenses are, if that's what the standard of living is and it's properly documented, I think absolutely.
Okay.
The other thing is one thing that council keeps pointing out is whether or not there's demonstrated need and whether or not that's been read into the statute and so forth. As I kind of pointed out in my briefing as well, does this demonstrated need terminology ever really show up in the statute? It doesn't. I think it was a term of art that was created by the Court of Appeals. And even in the Dow case, why this court didn't adopt the demonstrated need terminology, I think it's very clear from just reading the statute on alone, and the first factor is the financial condition and needs of the recipient spouse are considered in determining alimony. To me, that's demonstrated need, and so I would just argue that it is there. I know that's been a big issue for the petitioner, but to me, I think it is there.
Then how do you read subsection 4A, which seems separate, right? It says the court may attempt to equalize the parties' respective standards of living. That doesn't, I understand that the case law says that, at least my interpretation is that you can only equalize up to meeting the need, right, based on the marital standard of living. But there's nothing in the statute that says that, so I'm just wondering where we get that from the statute.
And I don't want to correct the court, but...
Oh, I'm sorry, please tell me.
Sure. So I'm looking at, I don't know which statute, because there's several versions of the statute, but I'm looking at the 30-3-5, which was in 2021, which was the operative law.
Oh, I'm sorry, I was looking at the new one.
Okay. So,
Tell me where it is in that one.
so that terminology
Here it is.
is in subsection, or paragraph 9, subsection F. And in that it says the court may, and to me this is key terminology too, the court may, under appropriate circumstances, attempt to equalize the parties' respective standards of living. And to me, when I read the Court of Appeals cases, and they talk specifically about the fact is the Court of Appeals often finds like, well, if there's not enough money to go around, the terminology that the Court of Appeals has adopted is equalizing poverty.
Right.
And so that's where I think that paragraph has been, I guess, interpreted by the Court of Appeals and has been implied for as long as I could remember.
So my question though is that consistent with the statutory language? Because I agree with you, that's how it's been interpreted, that you can equalize poverty, right? And that means when you equalize the standard of living, you're still capped at whatever the recipient spouse's need is. But I just don't see that in the statute. So how do we get there from the statute?
To me, I think the statute is, if you look at the first factor, which is part of the Jones factors, when you're looking specifically at the financial condition and the needs of the recipient spouse. To me, that is demonstrated need, where it's, if she only needs, at least in this case, the $41.84, then after we do the analysis of what her income is and so forth and arrive at the $910, to me, that is the cap. because that's basically the first factor in the Jones. And then, of course, obviously, the second factor in the Jones factors is, of course, looks at the recipient's earning capacity and so forth as to how we arrive at that number. But to me, once you do that test, and certainly I think even Dow approaches on that and describes that test as well, there's nothing in the statute that says, which is what the court did, is, okay, fine, I got 910, but I'm just going to go ahead and double it, because to me then why are we going through this test in the first place? Let's just be honest. If we're going to just throw out the test and just equalize income, and that's basically what the court did. It's ignoring the test and didn't even provide proper justification for it. So to me, if we're following the Jones factors that's been codified by the legislature and certainly, originally by this court, then we have to follow it. But just to go ahead and say, okay, I got this number, but I'm going to throw it out and I'm just going to equalize income and come up with this 1970 figure is just completely wrong.
So are you saying that you can't just jump to F because A says the court shall consider at least these following factors?
That's correct.
Okay.
But once the court considers them, doesn't the statute give the court discretion to make adjustments in appropriate circumstances? Statute doesn't say the court can't, right?
Just so I understand your question, are you saying after it goes through the factors or before?
After it considers the factors. It has to consider them. It doesn't say you have to check a box or you have to go in this order or that you have to find a certain thing. It just says you have to consider these things. And then it says you can make an award and you can make this adjustment in appropriate circumstances. So I'm just trying to figure out how that statutory language confines the court's discretion short of the absence of some circumstances.
I guess the best way I can answer that question is, at least if we're following all of the case law from the Court of Appeals, it has laid out that three-part test very specifically over and over and over again. If we're applying it to this court, yeah, this court has never really codified that test. So I guess I'll leave it up to Your Honor as to whether or not the district courts are obligated to do so. I would say they're obligated to do so because that test has been in place for 30-something years, and this court has never changed it. And I just don't think that it would be appropriate for this court to change 30 years of case law and so forth, because that's just going to cause all sorts of problems on the trial level. But to me, if we're following it, then yeah, they're obligated to follow the Court of Appeals where it says you follow this three-part test and whatever it is, whatever that number is, then that's what the amount is supposed to be. Thank you.
Right. Okay, thank you. Counsel, you still have your 5 minutes for rebuttal.
Thank you, Your Honors. And I did look back. I didn't look line by line, but I think that the exhibit that was introduced at trial does appear to be at least similar, to the financial declaration.
Do you mean the, okay, so. let me
Sorry,
make sure
I just wanted to
know what
answer
you're
that
talking about.
question more clearly.
So
Yeah.
in D, this first thing that you have in your tab D that has that it equals the 5,193.79, and it's got all the expenses listed. You're saying that is the same as the financial declaration?
I believe so, Your Honor. It looks, I mean, I just kind of did a quick glance, but I think they are probably the same. But yes, Your Honor, I think what, kind of going back to this, I do think this is something that was raised for the first time by the Court of Appeals in its decision. This wasn't raised in the trial court. I believe it was invited error in the trial court. The argument was never, there's not enough evidence, not even at trial. I mean, at trial, the trial judge said, hey, we're going to equalize later, and the response was, okay, I believe, let me get the, he said basically like, I'm going through these now and then I'm going to equalize it to later. And at that point, Daniel, who was pro se at the time, said, okay, and that was at 5:06 in the record. Basically, he basically said, equalization will be done in part by the alimony payment, not necessarily at every line on the expense item that you have. So basically, I think it's if a remand is appropriate, I think, figuring out what, where these numbers came from the trial court would be probably appropriate, Your Honor, because it's clear that if the trial court is just basing this down to the basic needs, under rule in the first Gardner case, that is an error. Those cases were both reversed. And in the rule case, I think it's clear when you look at the demonstrated need that it is clear that more than the need needs to be taken into account, because the Court of Appeals cases that have used that standard have not said your demonstrated need is your basic need. They've kind of used it as the marital standard of living is the maximum.
And I think that's correct, but they have said that where the equalization comes in is if you have a shortfall, right? And as I understand your argument, you're saying that the statute, where it says the court may, under appropriate circumstances, attempt to equalize the parties' respective standards of living, is not limited to equalizing it to make up that shortfall. Is that right?
Yes, Your Honor. If you read the statute, that the legislature did not put that limit in the statute. That limit was created by the Court of Appeals.
Okay, but here's my question for you. The Court of Appeals created that over 30 years ago, right? What do we make of the fact that the legislature has amended this statute multiple times and has never attempted to correct that? Generally, we assume that if there has been a definitive, authoritative interpretation of a statute, and the legislature then goes in and amends the statute but does not correct that authoritative interpretation, that they have essentially adopted it.
Your Honor, I believe with the most recent recodification, the legislature did slightly change it. I don't know if that is, that's sufficient. They did take out the under appropriate circumstances, and I believe that the reason, if it hasn't been corrected, is probably because the way the Court of Appeals has applied this is that the Court of Appeals has said, if you make findings, appropriate findings, you can go above and beyond that, right? And I think that was the argument at the Court of Appeals level, is that the trial court went above and beyond but didn't make appropriate findings as to why. And so I think that the Court of Appeals interpretation does allow for some discretion, because the court can go above and beyond if it wants to. I mean, I think that's kind of, but it has to make the findings under the Court of Appeals standard. I think that's where that might be why. I do think under the current statutory framework, the appropriate circumstances was taken out, and so that could be an indication that the legislature wants it to be considered, that wants to give the trial court discretion regardless of whether, I don't know, I think it might be giving more discretion to the trial court under the new statute, if that makes sense.
Can we consider that when we're dealing with the statute that was in effect at the time? Can we consider later amendments to the statute?
Not to the extent that they're substantive, Your Honor, only to the extent that they clarify or procedural. I think that a lot of the changes that were made were more procedural. They were just kind of clarifying things. The part the biggest change to the alimony code is not at issue here. It was a provision to allow for adjustments to alimony on very specific circumstances that aren't at issue here. And it was creating a presumption of equalization in that case. And we're not arguing that there is a presumption of equalization here. But what I think our argument is here is that really the reason the trial court, I don't know why the trial court did what it did. I mean, it's not clear from the record. I would argue that during the trial, if you look back through the transcript, there are several times where Mr. Woodall says very clearly to the trial court, yes, Your Honor, but please consider the marital standard of living here. This should be based upon the marital standard. We're looking at these expenses based upon the marital standard. And so when the court is slicing them down, it's clear that he's thinking like what the needs are. And there was evidence at trial. There wasn't much as to how much was spent at trial, but there was evidence that every dime that they earned was spent. And so that gives you, that does show that there was a shortfall, right? Because neither one of them can currently afford to spend over, what the marital expense was because their combined income was lower and now they've got 2 households. So I think that it is clear that there wasn't enough to go around in this case, Your Honor.
You were saying that there is some Court of Appeals case law that the court could go above the gap between ability to earn and the marital standard of living in some cases that go beyond just equalizing the poverty. What cases talk about that most? Are there some specific ones that you're thinking of?
Your Honor, it was cited in the brief at the Court of Appeals in Daniel's brief. I don't have that off the top of my head, Your Honor, but I could submit a supplemental briefing, or, like a supplemental authority with the case names.
That's okay. And I just had one last question. So do you agree with opposing counsel that when the court is trying to make that initial determination of the standard of living at the time of separation, that it would be error for the court to say you were spending too much money on that? So if there's evidence that somebody, was very, very into their hair and they got a haircut every single week, it would be error for the court to say, no one needs a haircut every week, you could have just been getting your haircut every month. The issue is whether they in fact did get their haircut every week during the marriage.
Yes, Your Honor, I agree with that. And that's where the rule court and not the rule, we're in Rule N in the first Gardner case that the error was found, is because the trial court was clearly looking at, no, you're spending too much. This needs to be reduced. So I'm going to give you what you should have been spending, not what you actually were spending.
It seems like in the court's discussion with the parties, and there was a little bit of both. Like some of it, there was some discussion, for example, on entertainment expenses, where the respondent disagreed. No, we only went out to dinner twice a month instead of every week, which seems like an appropriate question for the court to try to figure out. But then in other instances about like the cost of housing, the petitioner said, what I'm seeing is for a 3-bedroom, I can get it for this amount. And respondent said, well, no, I'm living in a 2-bedroom for much less than that, which seems different than what the standard of living was at the time of marriage. So it seems like both were going on.
Yes, Your Honor, I agree. And I think that if a remand is appropriate, maybe some clarification as to what was being considered when by the trial court might be in order. But I think just for the Court of Appeals to sua sponte, where it wasn't argued and was arguably invited in the trial court to say, well, there's absolutely no evidence as to what the marital standard of living was, therefore we're going to go with the most basic needs that the wife has, was an error.
Okay, I just want to make sure I'm correct on one thing. Is it your position that in your Exhibit Exhibit D here in your brief, that all of that documentation is attempting to prove the standard of living at the time of separation?
Yes, Your Honor, but it was based upon what she is currently spending to meet those, to get back to that standard, if that makes sense.
So it's the expenses in 2021, but then to be viewed in light of the standard of living at the time of separation?
Yes, Your Honor.
I see, okay. All right, Chief, anything from you? I don't see a hand.
Nothing from me, just thank you to counsel for the arguments, very helpful.
All right, thank you very much.
Thank you, Your Honor.
And we will take this under advisement.
Thank you.